So, in beginning this series on the subject of dispute resolution for the SQE, I think it's important that we just begin by firstly looking at the first part of the specification, which of course requires us to understand the different forms of dispute resolution, essentially the different options which are available to a potential client who is going through a process in which they are disputing with somebody else over some kind of civil procedure matter. And in this case, there are a few different ways in which we can think about dispute resolution. You can think about the idea of what we call alternative dispute resolutions, ADRs, and these include things like mediation, arbitration, and negotiation. And then finally, you have the other options for dispute resolution, which of course exists in the form of litigation, being able to go about litigating and going through civil procedure. Now, I'm going to outline each of these in this video, and then what we will do is spend the next few lessons talking about each of these individually. So, essentially, it is a fact of everyday life that people engaging in society may find themselves in some kind of dispute, in some kind of civil dispute. This is just one of those facts of life, whether this is some kind of business dispute, whether this is a dispute that concerns contracts and contract law, whether it concerns torts or land transactions or some kind of commercial issue. There's always instances in which there may be some kind of dispute that exists, and there may be some kind of difference of opinion that may require legal resolution. It may require some kind of legal recourse, potentially require legal recourse, but not necessarily in some cases, as we will get to the broad conversation surrounding what the purpose of ADR is even all about. The perception, ultimately, among civil litigation and in civil litigation is that the resort to litigation, the sort of idea of going to litigation and going to use litigation as a source of dispute resolution, should be the last course of action. It should be the final course of action where a lot of other issues have already, or a lot of other methods, should I say, have already been negotiated and discussed, and attempts to resolve the dispute have already been attempted previously or prior to the use of litigation. In fact, courts will look disfavourably on one side or the other if they have refused to engage in some kind of alternative form of dispute resolution and have been seen as too keen to essentially go about the process of litigating this issue and go about actually having a legal case be resolved by the court. They would actually look quite disfavourably on that particular side because it is shown that they have not made every effort to try and resolve the dispute through means that are not litigious, through means that are not involving litigation. And so alternative dispute resolution, you might be interested to know, is really a collection of different modes of dispute resolution. And it is really here in ADR, in alternative dispute resolution, that the vast majority of cases are actually settled and the vast majority of cases are actually decided on. And whether the choice of whichever choice of dispute resolution they go to, of course, will have varying different advantages and disadvantages, which is, of course, the topic of the next lesson. But ultimately, if litigation is the last resort for parties engaged in the dispute, then there has to be a number of different means by which disputes are resolved that are not litigious in nature, that are not involving litigation. Essentially, there has to be a number of options available for the parties to actually resolve a dispute that is not litigious, often before any case makes it to the stage where litigation is required. These are known as alternative dispute resolution. These are known as ADR. And ADR exists in a number of different forms. We can see that there are a number of options. If you were a solicitor and you were advising a client on what they ought to do in a situation where a dispute arises, you, of course, having to deal, if this is, for example, a business dispute, you have to balance the fact that you want to have a resolution that is favourable to your client, but also a resolution that is favourable, that is not too costly. And litigation is often very, very costly, very, very long and drawn out. And so maybe one of these different forms and one of these different options for dispute resolution provide the client with a better recourse to resolve the issue than litigation may. Mediation is going to be the first of the types of dispute resolution that we spend our time looking at. This is where the parties to a dispute essentially agree to let a neutral third party, who is known as the mediator, help reach a mutually acceptable resolution. It's a very informal process. I guess you could argue that litigation is similar in terms of its definition, in the sense that a neutral third party, i.e. a court, will decide and help the parties reach a mutually accepted resolution, except of course this is done through the civil justice process, and it is done through the process of litigation. Arbitration is the next of our options that we're going to look at in the future videos. This is a more formal part of the process, a more formal option for clients who may wish to resolve disputes. This is where the disputing parties will agree to submit their dispute to an arbitrator. An arbitrator is a third party who will make a legally binding decision. Now, one of the benefits of arbitration, as we'll get to, is that arbitration often involves individuals, the arbitrator, who will actually have some kind of expertise in the area in which this dispute arises. They often exist in forms of maritime contracts, investment and investment disputes, or maybe construction and shipping contracts, things like that. These are the areas where the arbitrator often has quite a lot of expertise in dealing with those kinds of cases. And so you will feel good in the fact, and you might feel confident in the fact that you have received a particularly well thought out and reasoned decision. Negotiation is the most informal part of the ADR process. In fact, we're not really going to spend much time thinking about negotiation, because it's essentially a process in which the parties involved in the dispute may communicate directly to each other in order to try and help resolve the dispute, and maybe they could resolve the dispute by reference to a simple conversation. One side might admit that they were in the wrong, or they may agree to pay some kind of basic compensation or some kind of basic damages. Or even they may agree that one side is in the wrong, but that the other side thinks, you know what, it's not too big of an issue. Let's just make sure that this never happens again. You don't need to pay any kind of compensation. A very, very informal process, of course, takes place through negotiation, which is why we're not really going to spend much time looking at it, partly because it is not part of the specification, but also because it is essentially as simple as that, a negotiation as is defined by the Oxford English Dictionary. The other two issues are more complicated and have their advantages and their disadvantages, of which we'll talk about in future lessons. Now, finally, then, in just summarising the types of dispute resolution, I just want to spend a little bit of time looking at litigation. If the parties ultimately fail to come to some kind of conclusion through this process of alternative dispute resolution, then it may just be the case that one party has no option but to commence litigation proceedings. That is, if the dispute is seen as essentially worth the cost of the litigation process. It might be the case that you have a particularly stubborn dispute that has gone through a mediation process, for example, and has not resolved the issue, but that at the same time you don't really want to be spending money on litigation, and so the dispute just sort of stays where it is, and nothing really is done about it. That's another way in which we see dispute resolution cases happen, in the sense that they are not resolved. They are failed dispute resolution situations. The main advantage of litigation is, of course, will necessarily resolve the issue. It has to resolve the issue because, of course, it will hand down a legally binding judgment from a civil case as part of a civil case. But it is, of course, far more costly than all the other forms of dispute resolution, and of course, it takes often quite a long time, a lot longer than most of these other forms of dispute resolution. So the disadvantage is, of course, it's going to cost you a lot of money, maybe even cost you more money than it's really worth. And it will also cost you quite a lot of time. Sometimes in big commercial and business cases, civil litigation may take years and years and years and years, and it becomes a very, very arduous and tiresome process.